I spoke on judicial precedent. I spoke on a due process. I spoke on stare decisis, and conclusively we made a
So you finish,
recommendation
yeah?
and conclusion. Yes, and then you
Okay.
said that yes.
Okay. Let me take my laptop and look at. I was looking at that your paper through my laptop. Let me take my laptop. I hope the battery is still there. Sorry, oh. Oh my God. Bá ń gbé chájà yẹn wá kó mi tún lè pa iná tó wà níbí. Kò sí nọ́mbà yẹn, kò sí nọ́mbà, ó mọ̀ pé kò sí nọ́mbà yẹn nítorí pé ti jẹun nẹ́pà tá a tàn. Ó yá lọ ṣáà lọ change sí nẹ́pà. Yes, I've seen the paper. Hello?
I can hear you, sir.
I've seen the paper. Let me go to what you people said about judicial precedent. First of all, let me be sure whether you covered the ground. Okay. Start deciding they discuss in their chapter 4. Please go to their chapter 4 and let's see. Let's go through what they said. Go to their discussion of importance of stare decisis. Okay. Then, Tafan Ninai. Oh, Tala Tibina. Ah, what Munelo? You didn't change to NEPA now? Well, Munelo now. Abi? Okay. Well, Munelo. So what happened? Okay, gentlemen, I am troubled here. We all know stare decisis now. There is no lawyer who has not heard of the word stare decisis before. We all know what it means.
Stand by decision.
Yes. Well, how does it work? How does it work? What are the principles? What are the principles governing stare decisis? Is there, yes?
The principle of stare decisis flows from the principle of judicial precedence, meaning that the court must.
Sorry,
Hello, sir. What did
gentlemen.
you say, sir?
Wait, I'm coming.
Okay, sir. Hello, sir. Hello, sir.
He is coming. He has just excused himself. I think
Okay,
I have from the background. He's trying to fix his power supply.
okay.
Just hold on for him.
Okay, please, I just want to confirm if the members of my group are online. I saw Ilubete. I don't know
I'm
if
here. I was just speaking before the lecturer's prof's line went off.
is Adefora online?
Okay, I'm back. My light was giving me problem.
Okay, welcome, sir.
Okay. So, Prof, I was saying that the principles of stare decisis flows from the general principle of judicial precedent, meaning that the court must stand by decision. So, a lower court must follow the decision of the higher court, especially when it relates to similar principles of law, similar facts, similar principles and similar facts. Then where a higher court has made a decision with respect to such principles of law aligned with similar fact, then the lower court must abide or stand by decision. So stare decisis is a Latin word, means stand by decision. So the lower court must stand by decision of the higher court.
Good.
Okay, sir. Just to corroborate the position of my fellow member, in the case of Gabal and University of Maiduguri, say locus classicus and fair hearing, Gani was the one who handled that case. A committee was summarily set up to try Gaba, and then the age-long principle of fair hearing was violated. He was the one who was indicted. He was the one who set up the committee. At the end of the day, he was the one who gave verdict. And then Gani Fahimi had to call the attention of the court to the age-long principle of fair hearing, and that the court must stand by such decision because it has constituted the principle of precedent, and that's where this issue of stare decisis is flowing from. That you must stand by the decision of your superior and the superior courts of record. So just to consolidate and buttress the position of my member who just spoke. So stare decisis has to do with standing by your decision, even if such decision will lead to injustice or occasion injustice. And then we have some of the importance is that it leads to continuity, it leads to predictability, and then it brings about uniformity in our legal and justice system. That's it, sir.
Okay. There is an article I wrote in one essay in honor of Bola Ajibola, where I generally discuss the meaning and application of a precedent across legal culture. What do I mean by that? There is no legal culture that does not appreciate that judges should follow precedents. But what precedent means in one system is not what it means in one culture is not what it means in another culture. In the common law legal culture, precedent, or what we call stare decisis, is authority-based. What do we mean by that? It means that a hierarchy of court is drawn, and under no circumstances will a court that is lower in the hierarchy ignore decisions of the courts that is higher than it in that hierarchy. It's not a question of right or wrong, as you have found the Supreme Court saying that we are not, that the Supreme Court is not final because it is infallible, but it is infallible because it is final, something like that. So the common law basis of stare decisis does not necessarily suggest that previous decision may not have been wrong. But once facts are at all false, as between the present and the previous case, stare decisis enjoin the court not to relitigate issues, not to ask questions that have been answered before. And that is why you have the maxim, let it stand. What has been fixed should not move. Something like that. And so, why is it meant that in common law, they have their own style of precedent in a civil law system. In a civil law system, stare decisis is not authority-based. You do not say that because the highest court of the land said something, that will constitute the law on that matter. On the contrary, I said in that my write-up that our own idea of judicial notice is their own idea of precedent. You know that judicial notice is when a particular principle, maybe of customary law, maybe of foreign law, maybe of unwritten law, when it has been acted upon so rapidly or so consistently by the courts that it would amount to a waste of time to ask the question again. In customary law, for example, we say that you need to prove and plead customary law because it's a question of fact before the English types of courts. Okay? But we say that some aspect of rules of customary law have been so consistently pronounced upon by the court that you'll be wasting everybody's time to ask the court to determine those questions anew. So we say that such rules of custom, such position of custom would have been judicially noticed. And so the whole idea of judicial notice is that not one, not two, not three, but many cases have decided the issue. And when you are doing that, the position of the court that decided it is secondary. Okay? So I said in that my write-up that you will find that what we call judicial notice really is what they call judicial precedent. They do not attach a lot of importance to the position of the court pronouncing a judgment in the judicial hierarchy. Okay? So I said that is the difference between our own way of seeing precedent and their own way of seeing it. Okay? What else did I say in that write-up? You go get that write-up and read it, because I also discuss advantage and disadvantage. When you read it, you also see my cited footnote. You see debates between prominent jurisprudents that I dabbled into on the advantage, the pros and cons of our own style of precedent. Then if the principle, if the basis of our own precedent is authority and not popularity of a decision or consistency of a decision through many judges, if that is so, then we have to have some basic ingredient of our own type of precedent. And I then went ahead to say, you need two basic things. And you find them in all of the textbook on legal system too. Two basic requirements for having a system of precedent or our own system of precedent. The first one is, since you are saying that it is authority-based, we have to know which court is superior to which. That's what we call hierarchy of courts. There must be a settled hierarchy of courts for a system of precedent to operate. A settled hierarchy of courts. And the second requirement is that since it is decisions, previous decision that you want to cite as authority, there must be a system of reporting previous decision. Okay? There must be a system of reporting decision. So a settled system of law reporting. So those are the two requirements for stare decisis to operate. Then in that my paper, I went ahead to say, how does a system of precedent operate in the light of the hierarchy of courts? Using the English system as an example, and the major writing on the issue as at 1966 and after 1966. Originally, the highest court being the House of Lords in England, the decision of the House of Lords was considered binding on every court, including the House of Lords itself. Including the House of Lords itself. Okay? Then you had the English Court of Appeal. Remember the rule in Young and Young and Bristol aeroplane. Professor Bilade explains the rule in that case, regarding precedent in the Court of Appeal. Okay? Under what condition can the English Court of Appeal depart from his own decision in civil cases? In criminal. So, as I'm saying, we all know that story about how hierarchy determines which court is bound by which and all of that. But in 1966, the English House of Lords came up with a practice direction. And that practice direction was that henceforth, they can depart from their own decision. Henceforth, they can depart from their own decision. So whereas the position before was that even they are bound by their own decision, the position changed in 1966, okay, through a practice direction, okay, which permits them to depart from their own decision. But the English Court of Appeal continued to be subject to, I think the decision in Young and Bristol aeroplane was a 1956 or so decision. And it remained, what are the three circumstances, what are the three grounds upon which an English Court of Appeal can depart from its own decision in civil matter. In criminal matter, it is not bound by its own decision. But in civil matters, it can depart, it is bound by its own decision and can only depart from it under three circumstances. What are the three circumstances? One, if the decision has been overruled by the House of Lords. Two, if an English Court of Appeal decision is in conflict with another English Court of Appeal decision, okay, in which event the English Court of Appeal can pick and choose. And finally, the Court of Appeal can find that his previous decision was par incuriam. Okay? Par incuriam, you must understand the distinction between an error and a par incuriam decision. And anybody tell me the distinction between an error and a par incuriam decision? This is your basic legal system textbook. They explain it. If you read Obilade, what is the distinction between an error and a par incuriam decision? A judgment that was pronounced in error and a judgment that was par incuriam. What's the distinction between the two? People tend to confuse the two, but they are different. So what is the distinction between the two? Hello? Hello?
I can hear you, sir.
Can hear you, sir. We are with you, sir.
We are
Do you
with
know
you,
the
sir.
distinction between an error, a judgment pronounced in error, and a par incuriam judgment?
Okay, sir.
Yes.
I don't know if I'm correct. I just want to say that they're virtually the same thing. When a judgment is passed by incuriam means passed out of mistake, and
I'm listening to you, sir.
Oputa GSC said in that the Supreme. Sorry.
I said I'm listening
Hello,
to
sir.
you.
Okay.
I'm hearing you.
Okay, like Oputa said in the landmark case of Adekoye and Adesanya Limited that we are final not because we are infallible. Rather, we are infallible because we are final. Justice of this court are human beings capable of erring. It will certainly be short-sighted arrogance not to accept these obvious truths. For this court gladly accept the fact that it is far better to admit an error than to persevere in error. So when a judgment is reached by incuriam, it is reached in error. So the Supreme Court has said that they have a right to overturn their own decision when that decision is reached in error. And they are not infallible, even if they are final. So they have the possibility of making mistake. But I don't know.
Are you saying that a judgment in error is the same thing as a par incuriam judgment?
So that's
Can I say something, sir?
You can just help.
Yes.
I think a par incuriam judgment is usually declared par incuriam by a higher court, which means that the higher court has found its level to say, oh, the decision I made previously, it's no longer the position of the law because there was a mistake in that judgment. And as such, where the higher court declares that a decision is par incuriam, the lower court are no longer bound to follow those decisions. But when there is an error, it means that in reaching that decision, the court did not consider all the areas of laws. And as a result of that, they came to a conclusion that was wrong. So while one is an active act of a higher court saying that decision I've made in the past, should no longer be followed by lower court because I have declared it par incuriam, the other is not.
Well,
let me add to what he said, sir.
Yes.
I think par incuria occurs in the situation whereby a court is ignorant of its own decision, and as a result, come up with another decision different from what had been earlier decided. So then I adopt his position on error when all facts or laws are not examined on a particular issue, that may be said to have been reached in error. But when it is par incuriam, it means there is an ignorance on the side of the court that a decision in respect of a subject matter was already in existence before a new decision is reached. Thank you, sir.
Good. Very good. Both par incuriam and error are errors. But par incuriam simply means that the court did not know or apply a binding decision as at the date the judgment was pronounced that would have ensured that the case was differently decided. That happens almost all the time. Almost all the time. That you will find that there was a Supreme Court decision that the Court of Appeal, if it had relied upon, would have decided differently. So when the Court of Appeal then decide on the basis of plethora of Court of Appeal decisions, the judgment of the Court of Appeal must then be par incuriam. In subsequent cases, if you cite that Court of Appeal decision, okay, even in the Court of Appeal, and somebody cites the Supreme Court decision that was decided before that Court of Appeal decision, counsel who is citing the Supreme Court decision should be able to tell the Court of Appeal that that particular Court of Appeal decision should not be relied upon because it was par incuriam. Because as at the time it was decided, there was a binding decision that the judges did not know of. But having said that much, judgments do not turn upon precedent alone. They turn upon other sources of law. Like, for example, a court might be interpreting a rule of international law. A court might be construing a statute, okay? And it might be that as at that time, the statute has been amended, okay? So it's just like the same par incuriam, but this time around, what was omitted was not a judicial decision, but another source of law, okay? So that is the subtle distinction between the two. The two have the same implication, okay? The two have the same implication in the sense that they tend to render a decision that suffers either from error or par incuriam, not to have a weight. But you will see that the courts have themselves said that in order to ensure order, it is not for a lower court to point out that error. You have to wait until the case gets to the same court that made the error. Or if the same court persists in the error, a court higher than it to correct the error. That's what cases in the line of Samiya and Bauchi Native Authority and all of that decided. Okay? So, and I said the position in England as an 1966 was that even the highest court, apex court of a land at common law was banned by its decision, but a practice direction was issued. Go and find out the case in which that practice direction was issued. And most common law countries have followed that practice direction. Nigeria has followed the practice direction. And since 1970, since the case of Johnson and Lawansi, we have seen cases, plethora of cases where the Supreme Court identified that they were wrong and they corrected their errors. So identify those cases and what the Supreme Court said. Like one of them is what somebody read out now, okay? So what are the grounds for an apex court in a common law jurisdiction to be able to overrule itself. Reasons have been given. The court should not perpetuate errors. Okay? The court should do justice, etc., etc. Okay? And we have seen Nigerian cases where the apex court have overruled themselves on several points. For example, on the issue of jurisdiction of the state high courts. Okay? With regard to, that's the one I can easily remember. Maybe it's because it's a small area of practice that I'm into. On the issue of customary right of occupancy. Supreme Court once decided that if you start a case relating to declaration of rights or title to customary right of occupancy in the state high court, you have done nothing because the state high court has no jurisdiction. Simply because the relevant section of the Land Use Act vested jurisdiction in that matter on the customary magistrate courts, the lower and inferior courts. But subsequently, the Supreme Court was well addressed by counsel who referred to the unlimited jurisdiction of the state high court. It used to be section 236 of the 1979 Constitution. It's now, I think, section 272 of the 1999 Constitution. Okay? And because several cases have come up where the Supreme Court itself has said that as at the time when the jurisdiction of the Federal High Court was not exclusive, it could only be concurrent with the State High Court, because once you give a court unlimited jurisdiction, there is no other court with original jurisdiction that will supersede it. There is nothing any other court can entertain that it cannot entertain. On the other hand, there will be many things that other courts cannot entertain that it will entertain. So based on that, argument was now placed before the court that the fact that the Land Use Act says you should begin from the customary court or area court or magistrate court does not mean that if you choose to go to the state high court as your court of original jurisdiction, that the state high court will not have that jurisdiction, because the provision of the Land Use Act cannot run. If it runs contrary to section 272 of the Constitution, then it will be to that extent null and void. So we saw the Supreme Court arriving at a different conclusion in subsequent cases, formally overruling itself. Okay? NEPA and the Degbero, the Supreme Court also overruled the previous decision. Johnson and Lawansi, the Supreme Court, I think the issue in that case was the proper construction of recitals that are, is it 20 years old or whatever? And the question was, how do you calculate the 20 years? Okay? The Supreme Court in previous cases like Omosoya and Danifowoshe had given a certain interpretation, but in Johnson and Lawansi, the Supreme Court formally overruled. The importance of Johnson and Lawansi is that in overruling previous precedent, Supreme Court also overruled a Nigerian case decided by the Privy Council, which we used to illustrate to students in the legal system that the Privy Council rank equal to our Supreme Court, provided the appeal is from Nigeria. Okay? So So that is that. We are in a jurisprudence class. We are concerned mainly with the pros and cons and our understanding of how it operates in a common law legal system vis-a-vis the civil law legal system might also be of help. Then, how does it operate? How does stare decisis operate in Nigeria? What are the peculiar Nigerian issues? What are the peculiar Nigerian issues? Take any legal system textbook and refresh your memory. What are the peculiar Nigerian issues in stare decisis? Obilade talk about English types and non-English types of courts. Obilade said that stare decisis as a doctrine is a function of the practice and procedure of a court, and that all of the English types of court will always adopt practice and procedure identical to that of identical courts in England. But the other courts, Sharia Court of Appeal, Customary Court of Appeal, Customary Court, Area Court, they do not adopt that. So for him, you have to appreciate that when you are talking about stare decisis, the primary courts where it operates are the English types of courts. But he has a question. If you do not want anarchy, once a system of appeal has been created such that you could appeal from the non-English types of court to the English types of court, then you have to accept that the president of the English types of court may also
Sorry, sir, we can't hear you, sir.
I said, look at the peculiarly Nigerian issues with stare decisis. The first one, which Obilade addressed, is the question of some courts not being English types and others being English types. So the English types of courts are the ones that are primarily, by practice and procedure, bound to follow precedent. But Obilade says, because we have a system of appeal, sometimes from the non-English type of court to the English type of court, you will be creating anarchy. If you say that because they are not English types of court, they are not bound by precedent, they can therefore freely depart from what has been handed down to them by the appellate courts, that will be absurd. So on that note, they would also be bound by precedents, especially as they relate to judgments handed down on appeals moving from them. Okay? Then the most common issue we have in Nigeria is the issue of conflicting decisions. The issue of conflicting decisions. You find that being treated with respect to Court of Appeal and Supreme Court. When one Court of Appeal decision conflicts with another Court of Appeal decision, in the third case, which one do you follow? That's one. Two, when two Supreme Court decisions conflict with themselves, in the third case, which one does the lower court follow? And three, when two Supreme Court decisions conflict with one another, in the third case in the Supreme Court, which one does the Supreme Court follow? So what are the different formula that the courts have given at different time? Go and read Professor Oyewo's article. Professor Oyewo did an article in Journal of Private and Property Law. I think in their 1994 Journal of Private and Property Law, something like that. Go and find out and read this article. And he says that the courts have come up with 3 different solutions. Okay? The first one is pick and choose. The second one is apply the latest decision. The third one is Court of Appeal should make reference to the Supreme Court so that they should determine the conflict. Okay, there should be what you call case stated. State a case. Let the Supreme Court resolve the issue if 2 of their previous cases are conflicting, instead of picking and choosing. So that's option 1. That's option 3. Option 2, pick the later of 2 conflicting decisions of Supreme Court. Option 3, pick and choose. Choose anyone you want out of the 3. So Oyewo concludes, having reviewed the cases as at the time he was writing, he concludes that the third option is the best option, that it is the option that will conform really with the doctrine of stare decisis itself, that if you pick and choose, the meaning is that you are not following the doctrine of precedent, because the one you did not choose, you have indirectly overruled it. Okay? If you pick the later decision, you have not done right, because it is possible that it is the later decision that was par in curiam the earlier. If the later decision was given being unmindful of the earlier decision, then for all intents and purpose, you will say that maybe the Supreme Court gave a par in curiam decision. And since the position of the cases is that it is the court that gave a par in curiam decision that can declare it par in curiam by itself. If the Court of Appeal will now go and say it is following the later decision, what it would have done would be will be wrong. So these are the 3 options. Those 3 options, Oyewo examined them and said that the one that says a Court of Appeal or any lower court should
Sorry,
make a
sir,
case
didn't get the
stated.
third one.
Go and read. It's an LLM class. So I'm not teaching like LLB. Go and read Oyewo's paper. But what he said is that why he preferred the third one, according to him, is that it conforms with the principle of stare decisis. Okay? Because stare decisis says if there was an error or a par in curiam decision, let the court that made that error be the one to pronounce so. So if you now pick a later one, what you are doing is you are helping them to declare the earlier one wrong. And it may be the latter one that was decided par in curiam the earlier one. And so the best thing is leave it to make a case stated to the higher court to say this is the one that is wrong. Henceforth, follow this one. Okay? But what you will find in preponderance of Court of Appeal and Supreme Court decision is that idea of following the latter one. And I used to tell LLB students that it is the easiest way out. It means that if the Supreme Court gave a decision by 9 o'clock and gave another one by 12 o'clock on the same point and they are different, you just follow the one for 12 o'clock instead of doing any intellectual work. It's lazy. It's a lazy approach. It's a lazy approach. And so the best approach is, well, I have a limitation. I cannot decide that one Supreme Court decision is right and another is wrong. I refer the matter back to the Supreme Court to determine by itself. But the other question, which Oyewo did not answer, but which I have attempted to answer in some other write-up of mine, is suppose it is the Supreme Court itself that is to pick and choose between its previous decision. Is there anything wrong in that? But what you will find is that the Supreme Court, you find many decisions of the Supreme Court, that the Supreme Court will simply follow a previous Supreme Court decision because it is the later of two decisions. And I have criticized that to say that, well, the whole idea of giving the Supreme Court the ability to overrule itself is to correct errors. And so when you have two conflicting Supreme Court decisions, one of the two must be wrong. And there is nothing indicating that it is the earlier one that is wrong. So what the Supreme Court ought to be doing, if my lords are not going to really be lazy about the matter, is to review the two decisions and give us direction that, oh, sorry, we were wrong in this one. This one is right. This is the one you will follow. It is possible that it is the later one that is wrong and the earlier one is right. As you will see pointed out in some instances. So I think that is all that we used to discuss on style decisis. Of course, style decisis is a whole book, but those are the areas we have shown interest on. Pros and cons, comparison under our legal system with civil law legal system, brief historical perspective, the position in England as of 1966, the position post-1966, which most common law countries have adopted. How is it working in Nigeria? What is the bane of stare decisis in this country? The bane of stare decisis in this country, every lawyer knows, is that is conflicting decisions, especially of the Supreme Court. Conflicting decisions, especially of the Supreme Court. Okay? And how do we resolve the problem? How do we resolve the problem? Two-pronged answers. Supreme Court, two conflicting Supreme Court decisions cited in a lower court. Two conflicting Supreme Court decisions cited in the Supreme Court itself. We are saying that maybe the approach should be different in the two scenarios. In the first scenario, lower courts are not permitted to treat Supreme Court decision. So we follow Oyewo's reasoning that the best option will be make a case stated, refer the thing back to the Supreme Court and let them give us guide. Okay? The other scenario is two Supreme Court decisions, two conflicting Supreme Court decisions cited before the Supreme Court. And you find many cases where Supreme Court justices have said they will simply follow the letter of the decision. And we said that is contrary to stare decisis. It's contrary to the 1966 practice direction of the English court, which we have followed. Since the Supreme Court has the power to overrule itself, what it should simply do is to look at the two conflicting decisions, and if you cannot distinguish them, say that we are sorry, we were wrong in this one, but this is the correct one. Okay? So, of course, you have to know that counsel can also contribute to the matter. If you have two previous decisions that are conflicting, the rules require that you let the Supreme Court know so that they can constitute a panel of 7, a full court. So if you don't do that and you don't point out something to them, they might just simply answer you by saying that they are following the latter decision. But since they have power to overrule themselves, you need to invite them to do so. Okay? So, gentlemen, what I will do for you with regard to this third decisive aspect is to, since I've not read what these people have presented, so give you references. Give you references to read. Okay, so that if we examine it, we're examining any particular aspect of it, will not be found wanting. So, on that note, we have ended our lecture. He wanted me to give you in to exam.
Yes, sir.
Yes, sir. We look forward to that, sir.
Okay, what I will do is, once I make up my mind, I will send it to your WhatsApp group. What you should read.
Okay, sir.
I will go over all your,
thank you very much,
all
sir.
your presentation.
Thank you, sir.
Yeah.
Thank you very much, sir.
Sir, we sincerely appreciate you. Thank you so much, sir. God bless you, sir.
Okay. Thank you very much.
Thanks for all the time, sir.
Yeah.
Thank you very much, sir. Thank
We
you.
appreciate you
Thank
for
you,
all
sir.
the time you have
Thank
with
you,
us.
Prof.
Thank you,
Okay,
Prof.
you're welcome.
Sir.
Sir, before we going to get your material, sir.
I will give you, I will send them to you between now and Monday.
Okay, sir.
That's okay, sir.
We appreciate, sir.
Thank you, thank you.
I'll still do a reminder to you during the week, sir.
Hello, sir. We also like the recording of your lecture, sir.
Yeah, you can demand for that and tell them.
Can we have the recording of this lecture?
When you click,
I don't know. I thought
the recording.
It's a third party that does the recording for
LLM.
us, right?
Yes, sir. Okay, so Adeforowa, there's a link. I've always explained it on the platform that if you press it, you will see it. Go to YouTube. All the recordings from the beginning of all the virtual classes, everything is there. Everything is there. So we've changed it so that you can have access. It's been just scroll up, you will see it. It's the new link I created and I pinned it. So if you check the pinned items, you will see it there. So as soon as the recording finishes, just go to the YouTube, you will see the recorded this thing class. You'll just get everything there.
Thank you.
If not putting your name for attendance, please do it because I'll soon log out too.
I've done it. I've posted my name. Thank you.
Sorry, I'm trying to. Is it possible that we have the link on the WhatsApp group, please? I'm trying to look for the link.
It's there on the platform already. It's already pinned. It has been pinned there since.
It's there on the platform
If you
already.
always scroll, if you scroll, you will see it. It's there. It even has the picture of Mr. Olami Biton. It has the picture. There's a
pinned is the past question.
That is it. So just go there. It's a YouTube link. You will see all the recorded messages. He's the one that is in charge of it.
Okay.
And I can't keep, because
I think it's no longer pinned. That's why.
There are only two things pinned on the group. There are only two things.
Yes, it's no longer pinned. Maybe
I will pin it up to 30 days now. I will pin it now up to 30 days now.
Okay,
so
thank
you.
Does that apply to other courses? LLM courses?
No, she is managing her only a Zoom. So it's the person who is managing the Zoom who can post it now.
Mary.
It's also a professor, so I have to get
if we can have some other recordings in YouTube too, probably. I'm just thinking, no.
I don't understand what you are asking. Whatever you are getting is only for the lectures, that's all. And I have to notify him at every time we're about having a virtual lecture. That's what I do. That's the standard, that's the procedure. So he gets it for us. And he has already told me that everything is in the YouTube. So when you go to the YouTube, you will see it there.
Okay, thank you.
Hello, Mary.
Yes, please.
Yeah, thank you. Thank you for all you do. Thank you for your sacrifice and all that. Thanks for calling me. Thank you very much.
Okay, no problem, Precious.
Thank you. I
Thank you,
appreciate it.
Precious.
Yeah.
Thank you, Precious.
Yeah, I can hear you. Adefora.
Please, I would like to talk to you under 1 or 2 minutes. I just want to get something from you.
Call him personally, please. Do that.
Please call him because they are going to end this recording very soon. So call him personally, please. Don't do it here. I'm just taking attendance. Then he's going to. I'm going to take attendance, and the host will end it. That's all.
Just end it. End this discussion. Thank you. Thank you so much.
Thank you, Mary.